Hello everybody, I'm David Balabanian. It's a great pleasure to be here with you. As you may know from the program materials, this particular panel is being sponsored by the Armenian Bar Association, which I had the great honor of serving as the first president 25 years ago. I was the default candidate for that office, the organization having been created by Frederic Mégrét, who between the time he convened the meeting and the time it was held, the organizational meeting was named Foreign Minister of Armenia, which precluded his service as president of the Armenian Bar. So by default, I was given that honor and enjoyed my association with the association for now quarter of a century. We had hoped to have on the panel, or expected to have on the panel, another president of the Armenian Bar, Edvin Minassian, who at the last minute fell ill and was ordered by his physicians to bed and not to the airport. His place, however, has been more than amply filled by Harut Sassounian, who, if you haven't read his some article he wrote either directly or indirectly, you probably wouldn't be in this room. Harut has served as the voice of, conscious of, the heart of any organ you want to name, the Armenian community for a very long time. He is the publisher and editor of the California Courier, which is regularly translated into half a dozen different languages and reprinted around the world. Articles from the California Courier turn up literally hundreds of other publications and blogs. He was also the founder and president of the United Armenian Fund, under whose auspices over $700 million worth of aid were transported to Armenia. But I think most importantly, Harut has shown himself over the years to be enormously reflective, thoughtful, and balanced in addressing issues of concern to our community. His weekly columns are a source of constant updating and information about key developments that affect our community, both in the United States, Hayastan, and indeed around the world. And we're really delighted with you here today to talk with us about the issue of reparations. To my right is Umit Kurt, who's one of those brave Turkish students that you heard about at Clark University, currently a PhD candidate, whose dissertation deals with the displacement of the Armenian population of Aintab, where he grew up. Yes. He is a student in the Holocaust and Genocide program there, and he has learned both Armenian and Arabic. Armenian and Turkish. On my left is Frederic Mégrét, associate professor at McGill, who is an expert in matters relating to reparations, with regard to individual reparations and group reparations, which is one of the topics we're going to be addressing today. Can everybody hear me okay?
No.
No? All right. Get closer. How's that?
Good.
Better? All
Yes.
right. As I said earlier, we're going to use a question and answer format because these are difficult and challenging questions. I'm going to pose some really sharp ones. But I want sharp questions from you too. So please do make notes as we go along. And we will reserve some time. We're starting a little late, but I think we should have some time at the end to get your questions. Because the topics we're addressing here today is reparations. I have spent a fair amount of time involved in legal matters related to the Armenian community, recognition issues, curriculum issues, and the like. Although I became interested in the question of reparations in part because of some of my own work and my own cases, which has in many instances touched on mass torts, compensation systems in situations that bear some similarity to the Armenian genocide. And I wondered to the extent to which these practical measures might find a place in implementing a system of reparations. I also sought to inform myself as to the thinking that has already taken place with regard to the design of a reparation system. And found that although there's been an enormous amount of attention given to the issue of recognition, there's been an enormous amount of attention focused on the question of denial, there has been relatively little attention focused on what a system of reparations would look like, how it would be initiated, who would control it, who would receive the property or the funds, how would they be distributed, What would qualify as claims? What types of appeals would be allowed? All kinds of questions which I, as a lawyer, would take into account in designing any system of compensation. Not entirely clear to me why the issue has received such little attention. I think in part there has been a belief that once recognition is achieved, reparations will follow a fairly well-worn path and be easily identified and administered. I don't believe that's correct. I think that the issues that I've identified would be just as present afterwards as before. I think another reason, and I believe it's going to become evident as our panel goes forward, is that reparations raises really difficult questions, which frankly many people would rather defer consideration. Indeed, it's so challenging some of these questions that I'm going to begin by asking the question whether we ought to be having this discussion at all. Because I think there are people in the Armenian community who would question the propriety of our talking right now about a reparations program. Some would say that it's premature, that the conditions for reparation do not exist. And unless they exist, and we know who's paying what, and under what circumstances, there's really no point in talking about these other practical, concrete questions that I've raised. And that at best, it's too early to have this conversation. Others would say that it's really much worse than that. That even opening these topics invites dissension, controversy, conflict within the Armenian community by raising the question of who would initiate the process, who would control the process, who would receive the claims, who would distribute the proceeds, who would make the adjudications. Indeed, I saw a comment attributed to an Armenian whom I respect greatly, that if the Turkish government really wanted to do enormous damage to the diaspora, the best thing they could do would be to dangle some money in front of the Armenian organization and let them fight over it internally and with their members. Sorry to say, I think there's some merit in that, and that a program of reparations would require greater discipline and greater coordination on the part of our community than, frankly, it has often shown in the past. I'm speaking very candidly to you, and I hope you will speak very candidly to us with your questions. Others would say that reparations are really not the issue. In fact, that would have some moral qualm about accepting blood money. My memory of my grandmother is far too sacred to me to barter it for money or even property. Others might say that a program of reparations lets Turkey off the hook. They can point to the program, particularly if it involves litigation remedies, as having fully addressed the subject, and there's no need either for acknowledgement of the past or for any other measure. Some would say that the conduct of the Turkish Republic in continuing the shameful program of denials is so morally abhorrent that the only proper response is just perpetual castigation, really until the end of time or until memories simply fade beyond repair. There are those who would say that if the topic is to be discussed, it shouldn't be discussed openly. It will be a meeting which undoubtedly includes people who will report what we say to others who may not have our interests at heart. And that if one is to design a program or a wish list, it should be done in private. All these are interesting and legitimate issues that need to be addressed. And I'm going to hurry to take the lead in addressing them.
Well, you asked about probably 100 questions. I don't know which one to answer.
Yeah. Well, take them in order. Let's talk about, do you think this is the time for us to have this discussion?
Well, okay, that one I can address. In my opinion, not only it's time, but it's time, long time ago was the right time to address this. We're way behind the curve on this, and we've far too long chased recognition, which we've done a pretty good job, all of us collectively worldwide. And only those who still do not officially recognize, I say shame on them. They're the ones who come to the table, they're the ones who look bad, and they have something to lose by not recognizing the obvious, the fact of history. But in terms of our demands, I think we should have organized ourselves, collected all the documents, all our demands, and all the studies, both in terms of physical entities, lands, churches, personal properties, We should have also gotten the right international lawyers, historians, all in various committees working on it, have funds set up to pay for their services, and then look at them, analyze the files, not people like me, but people who are really experts in international law, and then decide which issues to raise, under which court. There's international court where only governments can apply, there's European court, there are domestic courts in different countries. So all these legal decisions have to be carefully considered, prepared. So not only is it the right time now, yes, it's way past the time to discuss this.
Well, Professor, one of the topics we've been assigned is the question of group claims, and whether we're talking here about individual claims or group claims. We're talking about events that occurred a century ago, which obviously complicates the question of what groups we're talking about, whether they're in continuous existence. You've studied the question of reparations in a variety of contexts. Could you offer some perspective on that aspect?
Sure, and thanks for asking the question. I think it's a really important one. Maybe just to backtrack a little on whether it's time or not. I think this is one of the challenges is time. A lot of time has elapsed and does raise problems for the law. It may raise evidentiary problems in terms, for example, of not so much, if we're talking about reparations, we're not talking so much about proving genocide, but things that are much more specific, harm suffered, property confiscated, etc. So obviously the passage of time doesn't help. It doesn't help because it becomes difficult to establish things conclusively. It also doesn't help because a lot of legal systems have typically delays beyond which they make it more difficult to claim restitution or to sue another party. So that's obviously going to be a problem. It's a problem that's mitigated, I think, by an understanding that perhaps wasn't evident at the time the genocide was committed, but it's become quite obvious since, which is that certain international crimes, certain atrocities cannot be prescribed. In other words, you can seek punishment of those responsible, you can seek reparation decades, if not more, after they've been committed. And that's why we've been having a number of lively discussions on these issues of reparations, and it is becoming a global phenomenon. I think that's also one thing that's important to underline, that this isn't just the Armenian. In fact, the Armenian genocide is not the oldest. The issue of reparations for slavery, the issue of reparations for colonization, the genocide of the Herero in Namibia. So there's Canada recently has gone through a truth and reconciliation process dealing with certain claims raised by its indigenous populations. And so I think the time frame has expanded considerably, and that's something that is a really interesting development. Now, to go back to the question you were asking me specifically, which is, I think, a key question. The two are not necessarily incompatible. Of course, groups are made of individuals, and the sum of individuals constitute groups. Groups can bring claims for reparations in certain circumstances, or at least institutions, groups, organizations representing the core group as group, but so can individuals. So I don't have a simple answer to that. One thing that I would mention is, I think it may depend what the ground for seeking reparation is. So if you're alleging a human rights violation as a result of persistent denial by a state of your title to a certain property, that's fairly individual, and you'd go to the European Court of Human Rights. But if you're looking for reparations for genocide, then of course you can obviously be an individual victim of genocide, but there's a certain danger in seeking reparations separately and as individuals. And I think what makes most sense when it comes to seeking reparations for genocide is to think of genocide as a crime that is primarily and by definition targeting groups as such. Right? This is the original definition of a genocide convention as a legal definition. It is the intent to destroy the group as such. Therefore, and now of course you do that by killing and exterminating many individuals, but really beyond the individuals, it's the group, it's cultural, social, political life that you're targeting. And so I think in that respect it makes sense to conceive of reparations as also trying to put the group back in the situation it was before the atrocities were committed against it. Yeah.
Well, I realize you haven't studied the Armenian situation as intensely as others perhaps, but the group we're talking about here is the Armenian community of what is now the Turkish Republic, actually some other parts as well. How would that claim be asserted on behalf of a group? There are some other groups that really are Armenian churches, for example, which have had at least continuous existence in some cases, so that the proof problems associated with their claims are diminished.
Let me answer that question maybe by using an example and an analogy that I think is useful, even though it's very different, but which raises many of the same questions. And that's the negotiations between Germany after the Second World War and Israel as a state in 1952 for reparations for the Holocaust. But there's two major differences that, of course, don't make it exactly comparable. One, this was 1952. It was extremely soon after the event. Two, Germany was sort of bending backwards to atone for the Holocaust and was more than willing to pay reparations. But I think it raised tremendous issues within the Jewish world at the time. You mentioned a few things. I mean, you mentioned that this could have the effect of fragmenting the community. I think it certainly did. In fact, this is, to my knowledge, the only moment that Israeli democracy came under threat. There were riots just outside the Knesset. They almost, as the law that adopted the settlement was adopted, the mob almost invaded the Knesset, and there was significant civil unrest, hundreds wounded, etc. Now, why that commotion? You think, well, why, if you're an Israeli and like a Holocaust survivor, why not be very happy that Germany is committing to paying something like 6 billion Deutschmarks at the time? And I think there's several things. I mean, one thing that's really interesting is the structure of negotiation that was adopted. So Israel was obviously represented, but so was the World Jewish Congress. So the diaspora was represented. It had almost an equal seat to the state that was doing the negotiations with Germany. But what happened is, so a lot of people were very sensitive about this blood money insinuation. They felt that this was too easy for Germany, that there was simply no price could be put to the victims of the Holocaust. The Israeli government framed it in a way that was interesting. It said, this isn't reparations for the Holocaust. Well, that could never be compensated for. They said it's compensation for what it has cost the Israeli state to repatriate the Jews, the surviving Jews of Europe. And so it was about the construction of Israel. Now, the reparations were more than substantial. They've been paid for decades. And it's an ongoing process, which is also, I think, interesting. This is not just a one-off determination. It requires collaboration over decades. And I've read accounts in the early years. It was extremely tense. Some of the Jewish members of didn't even want to go to Germany to negotiate with Germans. And then over time, over decades, it had, I think, a powerful reconciliatory sort of effect in that they learned to appreciate that their German counterparts were honest about this. The sums were enormous, and they had a huge impact on Israeli economic development in those early years. I think it's calculated at one point, it's sort of accounted for 20% of GDP, so this was considerable. And I mention this because I know that sometimes in the context of Armenia this is mentioned, the problem of development, the problem of making the state viable, etc. So I'll leave it there for now.
What is the relationship between the compensation of individuals and state-related?
That's a very complicated question. So, I mean, if it's for the same thing, ideally you would want a situation where the state receives or organizations receive the reparation to distribute it. That's a model that's been adopted for the International Criminal Court, for example. Most of the time, reparation isn't given directly to individuals, it's given to representative organizations. That, you know, there's no perfect solution that can create problems. You know, I think if individuals are seeking reparation, for example, for lost property, that is something that is quite individual and that, you know, doesn't, the state, you know, no state can take away from them if one were to go to the European Court of Human Rights, for example. But of course, individual litigation, you know, is not simply egoistical and, you know, individualist. It's also can lead to very significant breakthroughs that are then, you know, create the space for negotiations with states and more structural remedies. So I think the two sort of exist, you know, dialectically in relation to each other.
Well, Professor Mégrét has raised the question, has identified as the affected group the Armenian population as a whole, as it existed at the time. Harut has devoted a great deal of time and a lot of ink to the question of who speaks for the Armenian community and how can we speak with a clearer, more unified voice. How do those comments apply to this situation?
Well, I think all of us Armenians were aware of the situation. We have the Republic of Armenia, we have the unrecognized Republic of Artsakh or Karabakh, and then we have a widely scattered diaspora in over probably 60 countries of various sizes. So in terms of, we have somebody who speaks, we have government in Armenia speaks for Armenian Republic, we have unofficial or unrecognized head of state, Bakos Aghan speaks for Republic of Artsakh, but we have nobody that speaks for 7 million Armenians outside of Armenia and Artsakh. We have many speakers, but not one speaker for the diaspora. As sometimes whimsically we say, the president of Armenia wants to know the opinion of the diaspora. What number does he dial? He has many numbers to dial, not one number. Therefore, for the last several years, I came up with an idea. I'm sure many people have thought before me, and maybe many people after me will think the same thing and may never see the day or time, but I thought of organizing the diaspora in terms of democratic elections. In each country, Armenians would elect for candidates that represent the community, and every Armenian in the country has one vote, you know, and regardless of who they are at a certain age, but whether they're citizen, legally there or not, if you're an Armenian, you can vote and elect your representative in your community. And then all these delegates form some kind of delegation that are authorized for the first time to speak in the name of the entire community, because the community elected them, and no self-appointed leaders. And then other similarly elected representatives in other countries, collectively, they represent the entire diaspora. Now, a lot of people will call that a pipe dream, or very difficult to accomplish. I agree. If it was that easy, it would have done long before I was born. And I'm still intent on carrying that out one day, maybe, if I can. But in the absence of such a structure, which we don't have now, and we may never have, to go through the head, and I think we have established, organized groups, we have political parties, we have other organizations, major organizations, and many of them are represented in the Armenia Fund. They do the annual telethon. There's a central group that have representatives in the body in Armenia, and that committee has the leadership of Armenia, leadership of Nagorno-Karabakh or Artsakh, and they have the heads of major Armenian organizations around the world represented there, so that could be a substitute. Or something that came up more recently, the President of Armenia made an announcement last September at a Diaspora Armenia conference, where he said that the various centennial committees that we have now throughout the world, and he proposed that those committees continue to exist after April 24, and they start dealing with various Armenian community issues post the genocide anniversary. So if that's the case, then we have Western U.S. Committee, Eastern U.S., Australia, France, all over the world we have, and we also have, similar to Armenia, we have a central centennial committee in Armenia, on which sit leadership of Armenia, Artsakh, and also all the major Armenian organizations. So if the day comes when the Turkish government wants to sit down, negotiating table, and talk to Armenians, I think the Armenian side of the table should be the Armenian government's leadership, the Artsakh leadership, and either the leaders of the Armenian community leaders, either elected by my pipe dream, or the existing group representatives who are sitting. And the important thing is, I think, what I'm proposing is that we have one delegation, not separate delegations, each one asking for something different or conflicting demands, but one delegation. And that delegation, before they ever sit in front of any Turkish representative, first they should sit, Armenians should negotiate with each other first, before they negotiate with Turkey. We should have one set of demands, one mind, agree what we want, what issues we raise, and then sit down with the Turkish representatives. Otherwise, there'll be a disaster. That's why I'm also opposed to any individual Armenian going and meeting with Turkish officials and making demands. Turks are very clever. They have 600 years of diplomacy, which Armenians don't. And what they're looking for, the Turkish leaders are looking for, and they said it themselves, these are their words, not my words, we're looking for soft Armenians, not hardline Armenians. I don't think anybody in this room qualifies as a soft Armenian, otherwise you won't be here. So if you're a soft Armenian, Turkey wants you, because you're the weakest link in the chain, and once they get you, it doesn't matter, even if you represent nothing and nobody, you're just an individual, they're going to make a big deal out of you, saying, so-and-so came, he's from New York or LA, and a prominent Armenian, and he said, just give me Mount Ararat and we call it quits, or whatever. Or just apologize and we're okay. We can't do that. We should all organize ourselves internally, agree on a set of terms and demands, then sit down and see what's the best deal we can get out of them.
How would you go about initiating that process?
I guess that's a question to me.
Yes.
Well, there are two ways. We've been doing it the wrong way. The wrong way is we do nothing and wait for one day, maybe a Turkish government will announce publicly, okay, we're ready to talk to Armenians. Where are you, and come forward, and who are you, etc. And then there's a mad scramble, trying to organize, trying to see who's who. Of course, every Armenian is a leader, and everybody's a chief, no Indians. And I think the right time to do that is before that day. We hire one or more people who are specialists in organizing such things. We give them the task. They sit down and plan. Then they contact various organizations or communities. They probably have to travel around the world and try to bring some kind of this unity of mind together, so that we're ready for that day, because we don't want to do this too late.
Professor Mégrét mentioned that although many of these claims are appropriate for group assertion, and in fact many only as a practical matter be asserted in that form, others, those relating to lost personal property that can be documented, may properly and may only be asserted on an individual basis. This requires some discussion of the status of legal property, real property in Turkey, the history of its evolution, the defenses that would be asserted to such claims based on so-called abandoned property laws. As it happened, our panelists Umit Kurt has studied this matter extensively and was going to give us a little bit of a tour through history for a while, and then describe the current situation with regard to land ownership in Turkey and possible claims that could be asserted, as well as potential offenses.
Thank you. I should be the only South Armenian here. So, actually, before delving into the historical trajectory of the so-called abandoned properties laws regarding movable and immovable properties of deported Armenians in 1915, between 1915 and 1917, we should also revisit our understanding of genocide, the definition of genocide, which was coined by the pioneering definition of Raphael Lemkin. In 1944, when he published his monumental book, which was titled Axis Rule of Occupied Europe in 1944, he made the definition of genocide by relying on the occupation of Nazi Germany in 17 European places by regulations, status, law, and legal procedures, let alone the physical elimination of the European Jewry and the Eastern Jews. He just talks about laws and legal rules and procedures to govern these occupied territories by the Nazi Germany. I think he was trying to give a different and distinct definition of genocide. He was trying to give a different message, and not only putting special emphasis on the physical elimination or physical, the wholesale total destruction of a given community or nation or religious group, but material destruction of a society. So that's the reason why, when we talk about Armenian genocide, we always focus on the physical elimination, the physical destruction, this massive amount of violence, but we tend to lose this material appropriation, expropriation, and the total material destruction of the Armenians. Armenians were totally despoiled, even they wouldn't be able to, bribe the gendarmeries during the deportation laws, because of all these series of laws. So you can carve out genocidal regime by using laws and legal rules, not only based on the violence. This is what Union and Progress Party and then the Turkish Republic did over the course of history. So what we are talking about is a series of laws, decrees, issues, regulations, which were promulgated during the Union and Progress Party period and then the Republican period. And the first and foremost law which was promulgated by the Union and Progress Party at this time period was the law which formed abandoned properties commissions in 34 different vilayets, different cities and districts of Anatolia, of the whole Anatolia. And this law was promulgated on June 10, 1950. According to this law, there was a stipulation that the government was saying that we were only administrating, protecting, securing those properties on behalf of our own citizens. None of the laws, none of the stipulations, none of the articles of these liquidation law and abandoned properties laws, there was no statement that we own these properties, we are taking those properties away from the Armenian hands. No, we are administrating, we are running those properties on behalf of our own citizens. Because otherwise, they would, dub themselves as robber, as thief. In 26th of September 1915, they promulgated one of the most significant laws of abandoned properties, which was called liquidation law. And this liquidation law stipulated the establishment of liquidation commissions in, again, this time, 35 different vilayets, different cities of Anatolia. And the major duty, the major function of those liquidation commissions was to liquidate, confiscate, and sell the abandoned properties of Armenians. In public auctions, selling the properties, distributing those properties to the refugees coming from the Balkan and the Caucasian regions, selling those properties in public auctions, and also giving those properties who actively participated in the deportation and the massacres of Armenians in different localities, and so on and so forth. And aftermath of the World War I, we are coming off with the new era, new period of time, and the CUP was toppled down, and the British forces were trying to put them on trial, those genocidaires. And then on June 12, 1920, there was a law which was promulgated by the Turkish government at that time. They were adults with the Union and Progress Party. There was a new government. And then this law was promulgated in January 1920 and annulled all legal rules and regulations and the legal mechanisms of the Union and Progress Party, and they start giving back the properties of Armenians to them. The Armenians who managed to return to their own localities. So what happened? The Kemalists, as a result of the whole war, Kemalists were the upper hand. They were victorious. And then what they did, they came up with and they promulgated another liquidation law by only revising the liquidation law of the CUP government. They had the same articles. They also promulgated the same regulation, which indicated how the liquidation law was supposed to apply. And then this law was the first liquidation law of the Turkish Republic, which was promulgated in 15th of April 1923. And then Lausanne Treaty was signed. During the Lausanne Treaty, unfortunately, Armenians were not represented sufficiently. They were almost ownerless, let's say. And then first and foremost, İsmet Pasha, who was the main representative of the Turkish government at that time, he first opposed to, the idea of massive returning of Armenians to their homeland. He rejected that. But he accepted, unwillingly, of course, individual repatriates, rather than the massive repatriate. For instance, a person from Garin region can manage to, return his own locality, but a number of Garini people, no. There was no way. And then another first and foremost prerequisition of the Turkish Republic was to not give any land, to reject, turn down land demand. It was the first and foremost, prerequisition. And there were, during the negotiations, that was the story, during the negotiations, British and French forces were trying to persuade the Turkish representatives to give, especially the Armenians of the eastern vilayets, the 6 vilayets, a certain region in eastern Anatolia. İsmet Pasha just got out of the room. And then during the Lausanne Treaty, as a result of Lausanne Treaty, Turkey committed to return the properties of Armenians to them, but Armenians who were managed to come back, who were managed to be available within the boundary of Turkey. Because there were many Armenians who were living in France, Britain, United States, and etc. Because Armenians were also, they also left the country during the so-called National Liberation War between 1919 and 1922. And then Turkish government at that time regarded those Ottoman citizens, Armenians, as fugitive and lost, and liquidated their properties. Because properties were abandoned, because the holders of the properties were not available. They were not in front of their properties. But during the Lausanne, there was a stipulation that, okay, we are going to give the properties of our own citizens back to them. But what they did, they changed the domestic laws. They, as if, they built a fortress, to not let Armenians, to not give any permission to Armenians from France, Britain, United States, to be able to return to Turkey. Armenians who managed to return to Turkey, they were forced up, and then they forced them to sign a letter and to put a stamp on their passport by, giving the pledge that, okay, we want to get back to, our hometown, but we are not gonna claim any kind of property. This is what they did. And there are many technicalities, there is a number of laws, I can talk, regulations and everything. I don't want to just get you bored about these laws. But the main idea, the mindset behind all these legal procedures and regulations, the mechanisms, just to not give Armenians a single inch. It was the main idea, was the main, endeavor to do so.
So where are we today? To sum up the current situation with regard to ownership of real property in Turkey, that I think is what would form the basis of further analysis of the reparation issue.
Yeah. Actually, this liquidation law of the Turkish Republic, the first liquidation law, which was promulgated on 15th of April 1923, this law has been valid until 1988, which means they kept on liquidating and confiscating any properties which they, overlooked, let's say. They made this law keep alive and intact to keep the liquidation, the confiscation, and also in order to prevent any kind of demands, which might have been coming from the, Armenians from different countries. The current situation is the following. Even the Turkish government or the state apparatus at that time, they did not comply with the laws, their own laws, liquidation law. In order to liquidate any property of an Armenian or your own citizen, you need a court case. But they liquidated the properties of deported Armenians especially by not waiting for the court decision. First, you need a court decision, court verdict, in order to confiscate, for instance, Armen Manukyan's house in Aintab. They didn't wait the court case, they just liquidated the house. So, there was an illegal and illicit, cases. There was full of illicit cases. They just behaved arbitrarily. And they only confiscated 20% of the immovable properties of deported Armenians by complying with these liquidation laws. 80% of the properties were liquidated on an arbitrary basis. The current situation is the following. Now, there are possibilities for having claims of individual properties. The properties of your heirs, for instance. You can always open a lawsuit within the boundary of Turkey and before the Turkish court by, of course, relying on a trustworthy lawyers in Turkey. First, you should just seek for your right, the property rights, within the boundary of Turkey, within the Turkish courts. Because the Turkish court has to take the case, has to take up the case, has to look at the case.
Yes, please.
Yeah. So I think this is really interesting because one of the big problems legally is, of course, a sort of problem of temporal application of the law. The fact that a lot of this occurred before the treaties under which you would normally bring a case came into existence. And I think one of the confusions quite often is that the genocide sort of happened in 1915 and then was sort of entirely consummated up till 1923, but then nothing happened, and therefore the events are sort of prescribed or occurred at least long before, for example, the European Convention on Human Rights entered into force vis-a-vis Turkey, etc. But I think what Umit's work shows is that there is, in fact, a continuous process. And that's very interesting because it means, in a sense, the genocide is legally still happening now, or at least some of its long-term implications. Now, the irony, I think, is the Turkish government, the confiscated property law, that was, in a sense, to sort of cover themselves, but because it creates this ongoing legal institutional activity, brings it into the present. And I think you're right that, of course, it is limited. You can't expect much of a remedy before Turkish courts, but Turkey is a party to the European Convention on Human Rights, and it's a serious party to the Convention on Human Rights. It means that there's a court in Strasbourg that can adjudicate on cases coming from individuals who allege that one of the state parties has violated their rights. I think something like this is in the works. But the next step, I think, is taking some of these cases to Strasbourg. And what's interesting about that also is it's not entirely tied to the genocide. I mean, you don't have to litigate for genocide. You don't have to invoke the Genocide Convention. You might want to strategically and politically. And of course, everyone is aware that this is in the background, this is the context. But what you're alleging is your right to an effective remedy, your right to access a court and get a remedy, your right to property are being violated. And so I think tactical victories can maybe be won on that front, that then would sort of open a space for sort of broader claims.
The topic of possible legal redress was on our agenda and was to be addressed by Edvin Minassian, who's not with us. But I have some idea what he was going to say, so I'll give you a somewhat second-hand hearsay account of
Is that admissible?
well, in this court it is. I'll ask Judge Justice who did. Of our understanding of the current lay of the land. I think it's very important, given the increasing attention being given to possible legal remedies, that we have a very realistic and well-founded assessment. A lot of loose talk about legal remedies being the next front, which Iranian claims for reparations and press, needs to be well considered and offer meaningful relief to the community as a whole. And I think that any program of legal redress has got to meet that test. So I think that it is incumbent on Armenian organizations and lawyers who wish to serve the Armenian community to apply themselves to the available options and to ask some very tough questions, which I'm about to do. First, there's the question of what, if any, remedies are available in the United States. Fortunately, the current lay of the land is very unfavorable to us in the United States for a couple of reasons.
We can't hear you.
Can't hear me. All right, I'll swallow the microphone. The lay of the land in the United States. I don't think I've ever had a microphone quite this close. The lay of the land legally in the United States is not favorable at the moment, primarily because of a ruling of the U.S. Supreme Court that addressed something called the Alien Tort Claims Act, which was the means by which people were able to bring into U.S. courts claims based on denials of human rights in other countries. What the Supreme Court said there in pretty clear, unmistakable language is our courts have a lot to do and with their domestic problems, and we're really not interested in opening them up to people who have grievances against other countries or citizens of other countries with regard to events that took place in other countries a long time ago. And that message has been understood and is being applied by the lower courts in the federal system and by the states as well, more bound. The other problem, and a special problem for our community, is the outcome of the Minassian case, about which there's a good deal of misunderstanding in the Armenian community. I think I understand the case because I was involved in it. I wrote briefs in it on behalf of the ANC and other Armenian organizations. The outcome of that case was unfortunate for several different reasons. First, it threw the case out of court. The case, just so everyone has it in mind, it's not a case based on the attempt to recover for genocide. The claim in that case, like the earlier New York Life case, was simply a contract case based on policies of life insurance written by the defendant's company on the lives of Armenians who had lived in Turkey and who had died for whatever reason, related or unrelated to the genocide, and been for whatever reason unable to or failed to present their claims. In the New York Life case, there was no adjudication, contrary to what many people believe. No one determined that the claim was valid. No one determined that there had been a genocide, because that wasn't the issue in that case. The only way in which even the question of genocide was raised in either of those cases is because contract claims, California at least, are governed by a 4-year statute of limitations. The California legislature, under urging from the Armenian community, had passed a statute similar to one passed at the behest of the Jewish community that extended the statute of limitations on certain types of insurance claims written on the lives of persons in the Ottoman Empire at a particular point in time. whether or not their deaths were occasioned by genocide or just died in their beds of old age. But the authors of the statute couldn't resist the temptation to refer to the period affected as the Armenian genocide. And that's what created the whole problem. Again, no need to prove genocide to assert a claimant, simply was a basis on which the statute of limitations was extended. Ultimately, the Ninth Circuit, after having first gone one way, was persuaded to go the other way and ruled that the mere presence of the word genocide in the case constituted an improper intrusion by a state, California, into the foreign affairs of the United States, which is a matter of federal cognizance, not state jurisdiction. That was all that was decided. Not that there wasn't a genocide, but simply that it was improper for California to use the word Armenian genocide in defining the period covered by this extension of the statute of limitations. Very technical, very narrow. Had the Supreme Court, which ultimately decided not to overturn the Ninth, not even to consider overturning the Ninth Circuit, hardly unusual, they only hear a tiny fraction of the cases they're asked to decide. Had they simply refused to hear it, I don't think anyone would be surprised or be unduly concerned. What happened, however, and what I think that makes the whole experience doubly regrettable, is that the Supreme Court asked the State Department for a statement of its position on the case. The State Department could readily have said that this doesn't, in fact, raise an issue of foreign relations, and it's really nothing in which we wish to be heard. They did not. They could have said that this is a matter of California insurance law and nothing of which we have any view. They did not limit themselves to that. They could have said that this does, in fact, impact our foreign relations in a way that is interferes with the conduct of our executive prerogatives, and we think for that reason the Ninth Circuit was right. They said that. They also went on to say quite gratuitously, quite unnecessarily, that not only was this an issue in which California had no business interfering, but that as far as this administration is concerned, the issue was closed. That it was resolved by treaties, which were not even raised in the Turkish brief filed in support of the Ninth Circuit's ruling. And that they really hoped that nobody would bother them with it again. There's been a lot of talk about unhappiness with the President over promises to recognize the genocide. But I think when we assess the overall scene, it was this statement from the State Department, from the Solicitor General, the Attorney General's office, Justice Department, transmitting the views of the State Department that was the most hurtful, and the one that probably most undermines any prospect of future redress legally in the United States, at least for the foreseeable future. European international courts are way outside my ken. I'm not going to venture. Harut knows a lot more about it than I do, and you may want to comment, but in a nutshell, as I understand it, claims in the International Court of Justice have to be asserted by Armenia for the most part. And with regard to individual claims in the EU, well, that is a possibility subject to the issue that the professor has raised, that the applicable laws probably weren't in effect at the time of the genocide itself, which is a potential procedural barrier. There is also a requirement, which Mr. Robinson referred to in his remarks the other evening, that the litigant to the claimant first exhaust remedies in the affected state, which then brings us to the issue of remedies under the Turkish laws. I think if you raised the topic of suing in the Turkish courts a few years ago, people might have thought it was a joke. Today, however, it is becoming an increasingly realistic option. There are lawyers, a few at least, in Turkey who are willing to take on some of these claims on a contingent basis. They are, however, subject to some limitations. It's very important to keep them in mind before you reach the conclusion that this is the avenue that we should pursue as a community. I don't mean by anything that I'm going to say that I'm going to discourage anybody who thinks I have such a claim from asserting it. If you do, by all means, consider your options, explore possibilities, and good luck to you. But keep these thoughts in mind. First, these claims, if they exist, relate to real property. They are not claims for the death, the wrongful death of scientists. They're claims for real property, and almost certainly they require some kind of documentary proof. What number of Armenians sought to grab their deeds as they were being hustled out of their homes into the desert is a question. Some people have been surprised how many have come forward with deeds, but I think the general view is that there's reliable statistics, but I think it is widely thought that the number is quite small. In addition to documentary proof of ownership, can you hear me okay, Sal? You look a little puzzled. Okay. In addition to documentary proof of contemporaneous ownership of the property at the time of dispossession, there's also the difficult question of proof of standing. How does the claimant who comes in with a deed demonstrate that he or she is in fact the lawful owner, the lawful successor of the person whose name appears on the deed, and the only one with a right to assert such claims? We're talking about events now 100 years old. By sheer geometry of succession and procreation, we probably are talking in many cases of dozens, maybe hundreds of people who could theoretically be descendants of the person whose name appears on the deed. This is an issue that would be the subject of dispute and potential defense in the underlying case. So, to sum all that up, I think one has to recognize that the potential, while it exists, is probably quite limited as to the number of persons whose claims are likely to succeed. Oh, one other variable. The property in question has to be worth pursuing. If it's a square of downtown Istanbul, you might get somewhere. If it's a goat pasture out in Anatolia, the lawyers may not be some-sided. And that's a factor too. The point of all this is that it would be a mistake, I think, for the community as a whole to regard this avenue as anything like a community-based, broadly based system of reparations that really provides meaningful redress for the experience that our community has gone through. Again, not to discourage any individual from pursuing it, but I don't think it is realistic or even fair for our large numbers of Armenians to think that this is indeed a meaningful path for community-wide redress. There is also some risk, and I invite other panelists to comment on this if they share my concern. Now, I have some concern that if this avenue, in fact, is realized, it's not at all clear that the Turkish government would allow favorable verdicts ever to be enforced, and there's that issue as well. We have to take an appeal to European Court. I guess I'm worried more about the opposite, that the Turkish government embraces this as an option and says, you know, our courts are open to anybody who's got a claim, you've got a deed, you're able to prove you own your property, come right to us. We'll even waive the limitations defense. And that's really all they need to do. And so I see the thing as the potential for it to some respect deflect, or perhaps even uncommon, maybe that's too strong a word, what I think of as a broad-based approach to reparations that would benefit the community more broadly, that might benefit organizations, that might help to provide remedy or redress, rebuilding in Armenia. I think that's all I'm going to say. Again, I've said it now 3 times, I don't want there to be any misunderstanding. This is not to discourage individuals who pursue these claims. Indeed, it's conceivable that they're doing so would help the broader cause. And I think everyone needs to have clearly in mind exactly what the limitations are, what the proof requirements would mean, what the challenges such claims would face. Harun or others, do you want to comment on this, what I just said?
Are we going to go on to other issues?
We are, yeah.
I mean, very briefly, I mean, there are obvious limits to what can be achieved by litigation. Obviously, the obstacles are in some cases insurmountable, and when they're not, it's that really we're dealing with a fraction of, I think, the historical claim to reparations, which would be just sort of issues of real property. I think it's important to note that when it comes to post-Holocaust reparation, most of it wasn't obtained through litigation, or at least litigation had a strategic political role enforcing either the German state or corporations at one point to come to a sort of broad political settlement that then created its own legal logic. So of course, if we're just sort of chipping at this mountain of denial and impunity and obstacles, then I think the prospects are pretty grim, and there's also a sense that everyone is sort of going at it individually, and that after a while that maybe weakens the sense that this is a community claim. However, I mean, I think there's, I don't know what's possible within the next 5, 10 or 20 years, but I think it goes back to the issue of why one would want reparations, right? Does one want reparations? Because reparations comes from tort law and the idea of compensation. There's a Latin idea of a restitutio ad integrum, that you're going to be put in the same situation that you were before the harm occurred, and that creates unrealistic expectation. But an entirely different way of looking at reparations is, it's not that we want to roll back all of the consequences of a genocide. It's just things that cannot be undone. In fact, it's morally problematic to want to sort of go too much in that direction, because there's only so much that can be achieved, certainly with money or even good political will. I think one of the demands for one of the ways of conceiving reparations is so that in the event, for example, if there is a sort of more, a sort of official recognition by the Turkish state, so that talk isn't cheap, so that you don't only just say, okay, I'll grant you that, but I'll do nothing about it. That you acknowledge a certain historical responsibility, and that you follow that up with sort of an effort to make amends. And so that's very different. And I think that's what the Germans did. They didn't think they could, eliminate the Holocaust. They said, we acknowledge a debt. And so you can see reparations there as being part of a much broader process of reconciliation, of making amends. And by the way, it's not just the victim community. Like, the Germans clearly felt that they would be a better state and a better society as a result of having paid the reparations. And they, occasionally, resisting a little, but by and large, even recently. So it's a fruit that keeps bearing. I mean, there's now, they keep opening the criteria for who can get reparations as a Holocaust victim. And now it's a sort of race against time, because it's calculated there's still a few tens of thousands of people who haven't benefited from reparations, to contact them wherever they may be, to give them, and it's not a lot, right? The money is insignificant, right? If you spend more than, I think it's 8 months in a ghetto, you're entitled to 3,300 euros or something. I mean, compared to the suffering and having lost your family. But, it's still, in aggregate, the sums are important. And so it's about German rehabilitation as much as it is about, Jewish, restitution.
Well, how do we get to some sort of global resolution of that sort?
Okay, well, I think we're getting now to the core of the issue, because, all of us around the world have been activists for the cause. We've marched in protest marches, we've written letters, we've passed resolutions. We're now, we started filing lawsuits, and we're thinking about filing more lawsuits. After a lifetime of activism, I've made the following conclusion: that we need to continue doing everything all of us have been doing on all fronts. Protests, books, articles, social media, lawsuits. It's not any one thing that's a silver bullet that's going to solve the issue for us. And the purpose for doing all of these things, it's not because we're going to get anything from any of them, but collectively, comprehensively, if we do all of these things, and we become such a major irritant to the Republic of Turkey, that's more and more is trying to regain its reputation, even though Erdogan's doing a good job of undermining his own kind of reputation by himself, so he's helping us. But eventually, people like Davutoglu are a little more sensible, and if there are others who succeed Davutoglu and get rid of people like Erdogan, who's more of a fascist, a tyrant type guy who doesn't care about reputation in the world. But if they're responsible Turkish leaders, they're going to come to us and say, listen, okay, we've done terrible things to you. It doesn't matter what we call it, genocide, crime against humanity, mass murder, massacre, ethnic cleansing, it doesn't matter. We've done terrible things. And if such a statement was made, by the way, all the way back in 1977 by the foreign minister of Turkey, then Sabri Çağlayangil, who met with the three leaders of the ARF, Rangravar, and Hençak parties in Zurich, Switzerland. It was a secret meeting, and they had an all-day meeting, and everything was openly discussed. And I'm collecting all the internal documents from all the parties sitting at the table, and one day I hope to publish them. And Çağlayangil said, what is it you want? I'm willing to do something. If you have something reasonable, I'm willing to do it. Armenian parties who had met in advance and agreed to say one common statement, demand, they said, we want our lands back, which is what we say today still. And I agree with that. But of course, it's out of question for a Turkish government leader to discuss returning land. They say, we don't owe you anything. This is the Republic of Turkey. And Çağlayangil said, if I promise you even a grain of sand, when I fly back to Ankara, you're going to lynch me. So aside from land, what else do you want? What else I can do? And they said, those are our lands and historic lands, our culture, civilization. He said, well, I may consider, I'll talk to my government, see if we can allow Armenians from Antep to return to Antep and Marash, and if there's no room there, we can put you in other areas of Turkey to accommodate. But anyway, there's some kind of I just mentioned as a precedent, as many of you are not aware of the 1977 meeting, but the more important point I want to make is that at some point a Turkish leader is going to be sensible enough, seeing all the damage done by our continuous activism worldwide on all fronts, that they want to cut their net losses and say, okay, let's sit down and talk, and what is it you want? And I think at that time, if we're ready, we're prepared with our demands, we have proper representation, the delegations organized, who's going to say what, who represents what, all that has to be done in advance. We can sit down, and then hopefully we'll get some things from Turkey. The Turks are not going to offer everything we want, of course, because they're the major power, they're in power, and we're not equals at the opposite ends of the table. They're the powerful, we're the weak side. But we have nuisance value, we irritate them, we do negative PR for them worldwide, so that's a cost to them. And to minimize that cost, they have to give something back to Armenians. Don't expect at that eventual meeting one day for the Turkish government to return Van and Erzurum and Garin and all these things, because they're not going to. And those things have to be done in some other format. As they say, land is not given, land is taken, or as I wrote before, there must be some catastrophe in the area, larger war, regional war, world war, something, a pandemic, something has to change on the ground for us to have an opportunity, but not, here's your land, come and take it. That option is out. But if we put for a second the territory, the demand for territories aside, we can ask many things. And my idea is to suggest the following strategy, because even sitting at a table can be at cost to us, regardless of the outcome. Because the Turkish government is going to exploit us sitting at the table as positive PR for them, saying, you see, we're third countries, US, France, don't meddle in this. We're talking directly to Armenians. And if there's no outcome that perfectly suits the Turkish government, because they already got the result they want, just Armenia sitting at the table with them, talking to them. So make sure that before anybody sits at the table, that the Turkish government takes some preliminary steps to show their goodwill. So some minor stuff, just they should do, see if they can do some minor stuff before we ask for major stuff. And I'm not saying the minor stuff is the solution to our demands. It's not. It's just a test of their goodwill, good faith efforts. For example, there's the tomb of Talat in the center of Istanbul. Imagine if the Germans had Hitler's mausoleum in the middle of Berlin. How would that look to the world? But yet, the Turks get away with it, and the world doesn't say a word. Many Armenians don't even know that there's a huge mausoleum that's 150 feet high in the middle of Istanbul at one of the major squares. And we never raise this issue, we never demand this. Not that they're going to take it down because we demand it, but it's one of the many things we raise, some part of our negative PR against Turkey. There are many, dozens of streets, dozens of cities and towns throughout Turkey. There are Talat Avenue and Cemal Street and Enver this and squares, and also the schools are named after Talat. And so, just again, make the comparison with Germany having Hitler Avenue and I don't know, Goring Square, all this. The world wouldn't put up with it, and yet, not only the world puts up with it, we ourselves don't raise it. We should, demand things like they should not teach denial to school kids in Turkish schools. They even teach denial in Armenian schools. They force them to write essays. They should also, outside of Turkey, they should not engage in worldwide denialism, hiring lobbying firms to deny, countering genocide resolutions or other resolutions in Congress, and then fighting us in France and in Greece, everywhere else. Those are some of the symbolic the test of good faith which that's from Turkey to do, even before sitting at the negotiating table, just to make sure that we don't just go there and then they use the meeting for PR purposes. If we go a little further, a little larger demands, not too large, but a little bit further, but this probably has to happen at the negotiating table, like asking Turkey to open the seaport of Trabzon on the Black Sea to give direct access to Armenia, so we don't have to go through Georgia, and so that there's a direct route from Trabzon to Armenia for and the duty-free items, zone front. They should. Another thing they should do probably falls in the minor preliminary steps to cancel Article 301 of Turkish law, where you can't say genocide and you can go to jail. They have restrictions on Armenian schools and churches that they should eliminate. Those are all, I consider, minor, easy to do things. The major ones are, returning all the churches, 2,500 churches back to us, compensating for the 1.5 million losses in terms of billions of dollars, returning schools, cemeteries, and of course, lastly, the territorial limit. So, and of course, one of the things that they should be doing right away is to lift the blockade of the Republic of Armenia.
Well, I promised you a very pointed, realistic, practical, detailed address of a topic that thus far has not received a great deal of attention, and I think that our panelists kept that promise. We started quite late, and we now are at the ending time, and I know some of you will want to leave, but I also promised the opportunities for those who wanted to ask questions. So if you wish, some of you can stay and we'll answer your questions, and if you have to leave or wish to leave, we understand that, and we thank you all for attending our program.